Hello, in this narration we are going to look at ownership, specifically the general principles of ownership. In this part of our narrations on ownership, we are going to look at the concept of ownership, the common law definition of ownership, and ownership entitlements. In this regard, the aim is to address the following study outcomes: to define ownership and explain the significance of it being a right that operates within the limits of the law, to define the contents of ownership and identify the standard ownership entitlements, and to explain and critically engage with the relationship between ownership and non-property constitutional rights. Now, as a starting point and by way of introduction, let's have a look at the concept of ownership. A definition of the concept of ownership is required or necessary in modern society, especially in capitalist societies such as South Africa. However, the role and content of ownership depends on the context, meaning the needs of society and effluxion of time impacts the content or meaning of ownership. More specifically, any understanding of ownership will always be based on historical, philosophical, religious, economic, political, and social considerations. This also tells us that when society changes, the concept of ownership also changes with it. For instance, the content of ownership, what it entails, the ability to exercise it in South Africa was impacted and changed not so long ago by a very specific project, namely apartheid or racial segregation. Legislation promulgated to advance the apartheid project eroded the contents of ownership of some racial groups, while strengthening the contents of ownership of a single racial group. While today, the constitutional context also informs, impacts, and shapes the content of ownership in line with its spirit, purport, and objects. And one does not have to look far to see how the Constitution in Section 25 of the Constitution has impacted the way in which ownership can be approached. Based on the aforementioned, it should be evident that no single universal definition of ownership exists. Yet, the existence of a definition of ownership is required in modern day society, especially in capitalist society such as South Africa, as mentioned at the start of this slide. The definition of ownership that finds application in South Africa is then a theoretical definition that is based on the common law and has been confirmed in case law. In other words, it emanates from academic literature, which shows the historical development of the concept, but more importantly, it comes from case law. So although academic literature tells us where we got the concept from and how institutional writers explained or described the concept, it is the case law definition that is the one that we apply and that we follow in South African law. Now, as mentioned, academic literature shows the historical development of ownership and the different views regarding the notion of ownership that forms part of South African law. It therefore shows the doctrinal or traditional and pre-constitutional conceptions of ownership. With this said, let's turn to briefly look at the origin of the conception of ownership as it is explained in literature and in South African law. The prescribed textbook from pages 38 to 41 includes an extensive explanation of the concept of ownership in Roman and Roman Dutch law and the influence of the pandectism on the conceptual understanding of ownership in South African legal literature. It also then sets out from a literature and academic perspective how the Constitution has impacted the concept of ownership, thereby really giving us a more current day view of ownership. I will not repeat that discussion here. Instead, I will just highlight some of the important points made there regarding the origin and historical development of the concept of ownership. Now, the concept of ownership forms part of the Roman Dutch law that was received into South African law. As you should know by now, Roman Dutch law refers to Roman law as applied and understood in Holland and influenced by Germanic law in the 17th and 18th century. Due to its Roman Dutch origin, the definitions of Bartolus and Grotius underlies the concept as we understand it today. Bartolus defined ownership as the right of disposal over a corporeal thing within the limits of the law. Grotius defines ownership as, or formulated a similar definition, namely that ownership is complete if someone may do with a thing whatever he pleases, provided that it is permitted in terms of law. And this is a translation. So both Bartolus' and Grotius' definition really tells us or acknowledges two things about ownership. The first one is that ownership is the most extensive real relationship a legal subject can have over a legal object, a thing, based on the part that states that an owner can do with the property anything he or she pleases. In other words, in Bartolus' definition, we see this through the right of disposal over a corporeal thing, and in Grotius' definition, we see this ownership is complete if someone may do with the thing whatever he pleases. But then there's a second element or part to the concept of ownership that both these scholars acknowledged or recognized. And this is that an owner's power is not without limits. It is limited by the law. This is evident from the part that states within the limits of the law. We will have a look at what this means in the context of the modern day South African concept of ownership in the slides to come. Now, the South African concept of ownership was also influenced by the Pandectists' notion of ownership. And the Pandectists are early German scholars of Roman law. The Pandectists supported a strong and absolute concept of ownership. They wanted a solid, strong, and absolute nature to be ascribed to ownership, to ensure stealthy protection of the right of owners over property, to prevent their country from falling back into the feudalist system that acknowledged fragmented rights rather than ownership. So the idea that ownership has an absolute nature or character then emerged into the academic writings of South African scholars concerning the notion of ownership, based on the theory of subjectivity or subjective private law rights that forms the basis of South African private law. It is, however, significant that although absolutism is ascribed to ownership by some South African scholars, the Pandectist notion of absolutism was never included in the definition of ownership by the South African courts. And this is it's the South African courts definition, so the precedent definition that we apply and we use in South Africa when having to decide cases. So that is the court's definition is the one that has the most impact in that, because it is actually applied, not the academics or scholars' explanations of the concept. So importantly, absolutism doesn't filter through into the cases being decided in South African law. However, from a theoretical perspective, ownership is described as absolute in several distinguishable senses in South African law to indicate different characteristics of ownership. Not necessarily to say that it is the strongest right that exists and it will always trump all other rights, but in a different sense. So absolutism is used to refer to something other than ownership trumps all rights. Now, these characteristics are known as the general theoretical characteristics of ownership, and we will have a look at them in the next slide. So, as mentioned in the previous slide, absolutism is ascribed to ownership by South African scholars. The Pandecta's notion of absolutism was never included in the definition of ownership by the South African courts, or the definition of ownership that has been used by and applied by South African courts. However, from a theoretical perspective, ownership is described as absolute in several distinguishable senses in South African law to indicate different characteristics of ownership. So not to indicate the Pandectist absolutist view that ownership trumps all other rights, irrespective of what rights those are, but rather to refer, absolutism is used to refer to other characteristics. And these characteristics are known as the general theoretical characteristics of ownership, and they include the following characteristics, or refer to the following characteristics. The first characteristic is that of completeness. Ownership is described with regard to its completeness. It is referred to as the most complete right versus other limited rule rights that are not that complete. And it's referred to as complete to distinguish it from other limited rule rights and personal rights. Because as owner, you have all the entitlements in your property, unless they are voluntarily or involuntarily limited, assigned to someone else. The second characteristic is that of abstractness. Ownership is said to be abstract since ownership constitutes more than the sum total of its entitlements, and since it is not exhausted or eroded by the temporary imposition of restrictions on the exercise of any entitlements. In this regard, ownership is referred to as a totality of rights. The third characteristic of ownership is that of individuality. Individuality refers to the idea that property is held by only one owner who has ownership. This means that there is one ownership that can be exercised over property. Although South African law provides for the concept of co-ownership does not constitute or negates or doesn't take away from this characteristic of individuality. It is still one ownership that is just shared by more than one owner or co-owners in undivided co-ownership shares. We will say more about the concept of co-ownership and also the concept of undivided co-ownership shares over property when we get to the part of our ownership narrations that will focus on co-ownership specifically. The fourth characteristic of ownership is that of elasticity. Elasticity concerns the idea that ownership has a residual character. And so if an entitlement is removed from it either voluntarily or involuntarily, such entitlement will return to the owner once it terminates in the hands of the assignee. Therefore, the owner is said to retain a reversionary right to the entitlement, which means that which means that the exact content of ownership is flexible. As the exact content of ownership is flexible and adaptable, it will be contradictory to say that there are a fixed number of entitlements that accompany ownership, which is said to be an elastic right. Now, in the slides to come, we are going to look at some of these ownership entitlements and what they entail. Also note before we move on that the characteristic of elasticity, of individuality, and of completeness really reinforces this idea of ownership being abstract, okay, constituting more than the sum total of its entitlements, and it not being exhausted or eroded by temporary impositions of restrictions on the exercise of any entitlement. Okay, now from the above mentioned, the academic conception of ownership and the theoretical characteristics, it is clear that even at common law, the concept and the content of ownership can by no means be described as absolute. Moreover, it is rather more appropriate to refer to ownership as complete, abstract, individual, and elastic when using the term absolute, instead of referring to the pandectist view of ownership when saying that ownership is absolute. Moreover, limitations are accepted to be part and parcel of the common law concept of ownership. This has been confirmed in the most authoritative definition of ownership that is found in case law and that we will look at in the next slide. As mentioned previously, the most authoritative definition of ownership in South African law was laid down in Gien versus Gien and constitutes the common law definition of ownership. It holds that ownership is the most complete real right a person can have with regard to a thing. The point of departure is that a person, as far as an immovable property is concerned, can do on and with his property as he likes. However, this apparently unlimited freedom is only partially true. The absolute entitlements of an owner exist within the boundaries of the law. The restrictions can emerge from either objective law or from restrictions placed upon it by the rights of others. For this reason, no owner ever has the unlimited rights to exercise his entitlements in absolute freedom and in his own discretion. In the next slide, we are going to focus on the features of ownership that arises or comes from this definition or this authoritative definition of ownership. From the Gien versus Gien definition, we can identify three features of ownership, namely, that it is the most complete real right, 2, that it is a right in one's own property, and 3, that it is not absolute, meaning it's not limitless in the sense that it trumps all other rights, irrespective of what those rights are. Let us look at these features in a bit more detail. Firstly, ownership is the most complete right a person can have on or over a thing. In other words, if you are the owner, your rights and entitlements to your property will be those with the most substance in relation to that property. No one can have more rights in the thing than the owner. If there is a right someone can have in a thing, an owner probably has it. Which brings us to the nemo plus juris principle, or maxim. This principle means that no one can transfer more rights than he has. In other words, a person cannot only transfer rights that such person has in a thing. A person can only transfer rights than that such person has in the thing, but cannot transfer a right that such person does not have in the thing. According to the maxim or the principle, only an owner can transfer ownership over a thing to a purchaser, or the agent of the owner can transfer rights. So someone with authority received from the owner will be able to transfer ownership to someone else. However, a non-owner cannot transfer ownership. Again, it goes back to the idea that if you have a right in the thing, you will be able to transfer it to someone else. But if you do not have that right to the thing, you will not be able to transfer that right. Also, if you are the owner of the thing, you can transfer all the entitlements and rights encapsulated in ownership to another person, and also limited or single entitlements in the thing. The second feature relates to the fact that ownership is the only real right that a person can have in his or her own property. This is encapsulated in the maxim "Jus in re propria sua," which means right to one's own thing. In this regard, ownership is not a limited real right, which is encapsulated in the maxim "Jura in re aliena." Limited real rights are rights a person has in another person's property, while ownership is the only real right you can have in your own property. I will show you a figure in a moment to help illustrate this. From the figure on the slide, ownership is located as a right in or over property. It is set out as a real right in or over property. As you would know from the rights study unit that you covered with Professor Miller, real rights are distinguishable or distinguished from personal rights. Personal rights are rights of legal subjects against others, and personal rights refer to purely contractual rights. However, these rights can impact property. Real rights, on the other hand, are proprietary rights that legal subjects has in or over property directly and applies erga omnes, meaning real rights can be enforced against the world at large. Now, ownership is located under real rights since it is a real right alongside limited real rights. The real right of ownership is a jus in re propria, a right that one has in one's own property, versus limited real rights being jura in re aliena, which are real rights that one can have in another person's property. And these definitions are the definitions we use to distinguish ownership from other limited real rights, or from limited real rights, since ownership is not a limited real right. Now, at the bottom of the figure, you will see various types of limited real rights that we will not be concerning ourselves with at this point, since we already looked at these in previous study units. Specifically, we've looked at real security rights, and you've looked at servitudes with Professor Miller. From now, it is important to locate ownership, or for now, it is important to locate ownership as a real right and know what it is or how it is different from other real rights called limited real rights. The third feature of ownership that emerges from the Geen versus Geen definition is that even though ownership is the most complete right in comparison to other real rights, ownership is still not absolute, where absolute means it trumps all other rights it comes into conflict with. This we also noted from the Roman Dutch definitions of Bartolus and Grotius in one of the earlier slides. In this regard, the notion that ownership in South African law is not absolute, despite what some of the academic works suggested, is evident from the fact that it can and is limited. It is therefore important to note to not confuse the completeness, meaning the idea that ownership is the most extensive right over property in relation to other rights, with ownership being absolute. It is only referred to as the most complete real right to distinguish it from other limited real rights, not to convey that it is absolute, meaning trumps all rights. The notion of ownership not being absolute is evident from the various laws that limits ownership. In the first place, or in the first instance, objective law limits ownership. Objective law refers to legislation and statutes, or provisions in legislation and statutes. For example, the legislation that regulates the use of firearms limits how a person can acquire ownership over firearms and how an owner of guns or firearms can use and dispose of guns. Just think about the example of regulations that apply to firearms that we covered in class discussion 1. Similarly, legislation that regulates the use of vehicles limits how owners of vehicles may use and enjoy vehicles. We can think of the fact that you need a license to use a vehicle. We can also think of the fact that there's speed limits that also limits how you can drive, how fast you can drive the car. We also know that there are certain roadworthy conditions before a vehicle can go on the road. So those are also regulations and legislative provisions that limits how a person can use his or her vehicle. The limitations placed on ownership by the objective law is involuntary limitations, since they are placed on ownership without the consent of the owner. They are placed on ownership via legislation. Secondly, subjective rights over property also limits ownership. Subjective rights refers to rights that other persons have over or in an owner's property. For instance, limited real rights in favor of someone else granted by the owner that follows the property and the successors in title of the property are examples of such subjective rights. Also, personal rights such as creditors' rights against the owner personally but not successors in title of the property can also limit the owner's ability to exercise her ownership as he or she wishes. In this regard, the limitations are generally accepted to be inherent limitations of ownership and can be voluntary limitations or involuntary limitations. The limitations would be voluntary in the event that the owner consented to the limited real rights or the personal rights, such as in the case of limited real rights, real security rights or a servitude. Okay, so for instance, where the owner goes to a bank, a creditor, and asks for a mortgage to be created in the bank's favor to secure a loan that it needs from the bank so that it can do something with the money. Okay, so that is a voluntary limitation that is placed over its ownership by the owner, it's him or herself. But these limitations can also be involuntary, where the subjective right that was created by operation of law, or where a subjective right is created by operation of law, or where the limitation is caused by another person's ownership over the property. Now, where the subjective right was created by operation of law, we can again take an example from real security. We can just think of Lens and the lesser stated hypothec to think of subjective rights that's created by operation of law in the common law, that creates real security rights, which are limited real rights, and which then limits the owner's ownership involuntarily. If we then look at where the limitation is caused by another person's ownership over other property, it also is quite interesting. And you look at this type of limitations when you get to neighbor law, or the study unit that will cover neighbor law with Professor Miller. Now, importantly, the Constitution also places limitations on ownership. In this regard, Section 25, the Property Clause, expressly states that property, which includes ownership, can be limited by law. You will also have a closer look at Section 25 with Professor Miller when you look at limitations on ownership in the next study unit. The constitutional rights that limit ownership that we will have a brief look at in this study unit are non-property constitutional rights and values. Examples of non-property constitutional rights that limit ownership include the fundamental rights of human dignity, equality and freedom, as well as other constitutional rights such as the right to freedom of movement, so those rights that you get in the Bill of Rights. Now, the prescribed case of Victorian Alfred Waterfront and another versus Police Commissioner Western Cape and others illustrates how landowners can be prevented from exercising their ownership rights to their property if rights or values in the Constitution are at stake. So, as explained in the V&A Waterfront discussion of, so as explained in the textbook, the court in the V&A Waterfront case considered an application for an order to ban the second and third respondents permanently from entering the commercial premises belonging to the applicant. The applicants applied for permanent interdict to prohibit the respondents from entering into and engaging in certain conduct on the premises. The application was based on evidence that the respondents have been misbehaving themselves on the premises over a period of time, interfering, harassing, threatening, and assaulting employees and visitors of establishments on the premises. The applicants, as private landowners, relied on their allegedly absolute right to exclude non-owners from their premises. They argue that the power to exclude others and exercise control over the use of property lies at the core of the entitlements of private ownership, which accrues to a property owned under the common law. Furthermore, the applicants submitted that a property owner is protected against arbitrary deprivation of property rights, including the right to exclude in terms of Section 25 of the Constitution. The court decided that owners of premises do not have an absolute right of exclusion and refused to grant a permanent interdict. Instead, the court granted an order that prohibited the respondents from behaving in certain specified ways on the premises. The court held that the applicant's right to exclude non-owners from the premises was qualified. The case shows that the right to exclude is limited by the fact that exclusion of the respondents would amount to a limitation of their non-property constitutional rights to freedom of movement. The applicant's right to exclude and the respondent's freedom of movement are both limited. The court recognized that the applicants have a right to protect their custom and business interests, as well as an interest in the physical integrity and security of their customers. However, effective protection of this right does not justify a blanket exclusion of the respondents. The court had to resolve the conflict between the landowner's right to exclude, in other words, the property rights under Section 25, and non-owners' non-property constitutional rights, namely freedom of movement, in a way that vindicates both rights to the greatest extent possible. The court concluded that this could be achieved by a prohibition of specified unlawful behavior on the premises rather than a blanket prohibition against access to the premises. The decision confirms that ownership is not absolute. Instead, it is subject to limitation by law, in particular the Constitution and legislation. The decision also shows that courts take into account the nature of the property involved in a dispute as well as the circumstances of the relevant parties. This is an indication that context plays a role in considering whether landowner's right will trump other rights. So in this example of the Victoria and Alfred Waterfront case also reminds me of the JAFTA case that we looked at under real security, and how the court also said that is where these two rights come into conflict with each other. The idea is to resolve the conflict in a way that vindicates both rights to the greatest extent possible. So then looking for creative solutions as to how to mitigate the limitations on both sides, but also then inevitably limiting the right a little bit on both sides. So we also see this in the case that is also discussed in the prescribed chapter, which is the more recent case of Daniels versus Crabante and another. You're welcome to read through that section in the textbook, specifically where this case is discussed, to also deepen your understanding of how a court will approach the situation where your ownership right comes up against a non-property constitutional right, such as, for instance, your right to human dignity, your right to security of tenure, and as we've seen in the Victoria and Alfred Waterfront case, a beggar's right to freedom of movement. Go read the Victoria and Alfred Waterfront case, summarize it, make sure that you understand how the court approached solving this conflict between ownership and non-property constitutional rights. Now that we understand the Geen versus Geen definition of ownership and the features thereof, let us turn to briefly outline the entitlements of ownership. The entitlements of ownership are those rights that are inherent in ownership, meaning that flows from ownership, and that determine the extent of the relationship that exists between the owner and her property, and between the owner and others. However, entitlements can be voluntarily or involuntarily limited by objective law and subjective rights, as we have seen already. Ownership comprises of several entitlements, and in South African law, it is not possible to provide a closed list of these entitlements, since the exact entitlements that would apply in a given situation depends on or is shaped by the nature of the property involved and the origin of a specific limitation. This confirms the abstractness and elasticity of ownership. Now, ownership entitlements may include the ius utendi. Ius utendi refers to the entitlement to use the thing. It is also linked to the entitlement to the fruits to the thing, namely the ius fruendi. The ius fruendi refers to the entitlement to enjoy the fruits of the thing. It is said that if you have the ius utendi, you automatically have the ius fruendi. However, the parties can agree that this automatic right of ius fruendi should be excluded from the ius utendi. So it is possible to include a clause in a contract that gives someone else other than the owner the ius utendi, that the ius fruendi must be excluded from the ius utendi. So for instance, if an owner of a flock of sheep agrees that another person A, can use the flock of sheep, so the person A now can use the sheep, and say for instance the sheep is also then in person A's possession. If the flock of sheep has lambs, and in the event that the parties agreed that the ius fruendi the ius utendi, the right to use and enjoy the property, does not coincide with the ius fruendi, then the lambs will not, or the person A will not be able to use and enjoy the lambs that came from the flock of sheep. However, if there aren't such a clause, or if there is no such clause included in the contract, person A will then also be able to use and enjoy the fruits of the property, namely the lambs. The third entitlement is the ius abutendi. Now, the ius abutendi refers to the entitlement to change, to consume, to dispose, or to encumber, meaning burden, the thing. It also includes the right to neglect, interestingly, and destroy. However, this entitlement to neglect and destroy may be excluded in certain circumstances. So it can be excluded in terms of express legislation that excludes the owner's ius abutendi to destroy or neglect property, or it can be excluded by way of contract. The ius possidendi is another entitlement, and it refers to the entitlement to be in possession, or broader, be in control of the property or the thing. It gives rise to the presumption that the person in possession is the owner. So if you see someone that is in possession of property, the ius possidendi gives the presumption that that person is the owner. However, this is a rebuttable presumption, meaning if you can prove the opposite, that this person isn't the owner, then the presumption of ownership will be rebutted. Another entitlement that flows from ownership is the "ius despondendi." And this entitlement refers to the entitlement to specifically dispose of the property. You also get the "ius vindicandi." And the "ius vindicandi" refers to the ability of the owner to claim the thing from anyone else who is in unlawful possession of the thing. So it's the right to recovery of the property. And we will look at how this right manifests in a number of remedies when we get to the study unit of protection of ownership. We also then have the entitlement to prevent any violation of the rights of the owner by another, which is the "ius negandi." And as just said, it refers to the entitlement or the ability of the owner to prevent any violation of his rights by another person. So in the previous slides, we covered the general principles of ownership. We looked at the definition and limitations of ownership, the contents thereof and entitlements, how it's limited, and also, very importantly, the relationship between ownership and non-property constitutional rights. Now, under individual title, all of what we've done in the previous slide applies. Okay, so please revise the general principles of ownership, including the entitlements that make up ownership from the previous slides that we covered. Under individual title, only one person holds all ownership entitlements by him or herself, and as I've just mentioned, that you can go back to the slides to determine what are these entitlements that an individual title holder, individual owner would have over property. Also go back to the slide to determine the concept of ownership that this person has, the theoretical characteristics of this ownership that an individual title holder has. Also determine how the right of ownership of an individual title holder can be limited by objective law, by subjective rights, as well as the Constitution, importantly. So obviously, as we stated in the last few slides, even if the owner holds all the ownership entitlements themselves, ownership is not absolute. And this we've seen from how ownership is limited by objective law, subjective rights, and the Constitution. So there are relevant limitations and restrictions. Now, for purposes of this module, as I've mentioned, you need to understand that everything we've covered in the previous slides automatically fit into and applies to individual title. In the next narration, we are going to look at the next form of ownership, namely co-ownership.